The morning I was 33 weeks pregnant and lying in an ICU bed with preeclampsia, my husband emailed me for divorce, drained our joint account down to $19, tried to cancel my health insurance, and filed court papers calling me mentally unstable. He thought I was too sick to fight back. He forgot one thing. I am a forensic accountant, and by the time a federal judge sentenced him to 7 years in prison, every dollar, every lie, and every forged signature had a paper trail. Chapter 1. The Email in the ICU. The email came in while 3 different monitors were tracking my blood pressure, and my daughter's heartbeat echoed through the ICU like a steady metronome that refused to slow down for anyone's drama. October 7th, 2024, UPMC McGee Women's Hospital in Pittsburgh, 33 weeks pregnant, diagnosed with preeclampsia that morning. My name is Alara Quinn Mercer. I am 32 years old. I have been married to Dane Mercer since June of 2018. At least, I thought I still was. The subject line read, "Moving forward separately." For a moment, I assumed it was one of those corporate emails he forwarded without reading. Then I saw his name in the sender line, and the world narrowed down to the size of my hospital bed. I opened it slowly because that is how I handle numbers and contracts and anything that can destroy your life. Slowly. He had filed for divorce. He wrote that it was best for both of us. He listed August 2024 as our date of separation. He used phrases like irreconcilable differences and emotional instability. It read like a performance review. August. I was 5 months pregnant in August. We were still sleeping in the same bed. He drove me to 2 prenatal appointments that month. We picked paint samples for the nursery. I remember him arguing over whether sage green was too trendy. I looked at the date on the email again, as if it might change if I stared long enough. It did not. The fetal monitor spiked slightly. A nurse glanced in through the glass but did not come inside. I breathed in through my nose the way Dr. Vega had shown me earlier. Calm. Steady. Do not let your blood pressure climb. I opened our banking app next. I did not know why. Instinct, maybe, or professional reflex. Yesterday, the balance in our joint checking account had been $58,240. We had built that slowly. Overtime hours, deferred vacations, bonuses rolled forward. Today, the balance was $19.14. I thought it was a glitch. I refreshed the screen. 3 ACH transfers within 36 hours. 2 for $20,000 each, 1 for $18,200. The timestamps lined up with the nights he said he was working late. I called the bank from my hospital bed. "Hi, this is Alara Mercer. I need to verify 3 outgoing ACH transfers from my joint account. Yes, I am currently hospitalized. Yes, I can verify my identity." The representative put me on hold for less than a minute. When she came back, her voice was careful. The funds were transferred to a personal checking account at a financial institution in Newark, New Jersey. The account was opened in March of 2023. It is solely in the name of Dane Mercer. March of last year. That was when he started CrossFit 5 days a week, when he suddenly cared about macros and protein intake, when he said he needed space to optimize. "Do you see the IP address associated with the login?" I asked. There was a pause. Then she read it back to me. It was our home address in Pittsburgh. He had done it from our kitchen. My hands were steady. That was the strangest part. I felt as if I were reviewing a client's case, not my own life. While I was still on the phone, my call waiting flashed. Unknown number. I let it go to voicemail. The bank representative cleared her throat. "There is one additional transaction pending, a transfer from Iron Bridge Logistics property account to the same New Jersey account. It has not fully settled yet." Iron Bridge Logistics is the company where Dane works as a senior financial analyst. So he was not just draining our marriage, he might have been draining his employer. I ended the call and listened to the voicemail. It was our health insurance provider. Ms. Mercer, we're calling regarding the change in your dependent status. A spousal separation was filed effective August 1st, 2024. Your coverage under Mr. Mercer's employer plan was terminated September 29th. An electronic authorization was submitted. My blood felt cold in my veins. That is not my signature, I said when I returned the call. I am currently in the ICU with preeclampsia. I have not signed anything. The representative put me on transfer to their special investigations unit. The woman who introduced herself as Cheryl Whitman sounded sharp and awake in a way that told me she had heard this before. We will place a fraud hold on the change request. Please do not discard any correspondence. If electronic signatures were falsified, this may constitute insurance fraud. I gave her the date, September 29th. I was in the hospital that week for monitoring. After I hung up, I called my dad. Thomas Quinn spent 30 years as USPS supervisor. He believes in paper trails the way other men believe in church. Dad, I need you to keep every certified mail receipt that comes to the house, and I need you to save the envelopes. Do not throw away anything. What did he do? He asked quietly. He filed for divorce, backdated it, drained the account, tried to cancel my insurance. There was silence on the other end. Then his voice hardened. If he used certified mail or falsified electronic signatures across state lines, that can escalate fast. Save metadata, save timestamps. We do this by the book. By the book. That is how I've built my career. I'm a PCA and a certified fraud examiner. I specialize in tracing hidden assets in high-conflict divorces. I know the playbook because I've dismantled it for other women. My phone buzzed again. A text from a friend. Are you okay? Why is Dane posting with some girl at your house? I opened Instagram. There he was, standing in our living room, the same room where we hosted Thanksgiving last year, his arm around a woman who looked barely out of college, Lila Hart, 24, CrossFit coach in Cleveland. She was wearing the pearl bracelet Margot Mercer keeps in a velvet box in her bedroom. The caption read, "New Beginnings." I stared at the fireplace behind them. Our wedding photo was still on the mantel. Nurse Callie Dunn stepped inside to adjust my IV. She looked at the monitor and then at my face. Everything okay? My husband just filed for divorce by email. He drained our joint account and tried to cancel my insurance while I'm in the ICU. Her mouth opened slightly. Then she closed it and checked my blood pressure. I'm so sorry. I am a forensic accountant, I told her. I find money people think is hidden. She blinked. So this is not going to go well for him. No, I said. It is not. The monitor beeped steadily beside me. Isla shifted inside my body as if she sensed the shift in mine. I looked at the email again. August separation date, emotional instability, joint custody implied. He thought I was too pregnant, too sick, too distracted to fight back. He thought wrong. I opened a new spreadsheet on my laptop and titled it Mercer Case October 2024. Then I started with the first transfer, $20,000. Follow the routing number, follow the timestamp, follow the IP address. Follow the money. Chapter 2. Follow the money. They moved me out of the ICU 2 days later, but the relief was temporary. The machines were gone, yet the tension stayed in my chest like a second heartbeat. Dr. Marisol Vega stood at the foot of my bed and explained that my blood pressure had stabilized, but preeclampsia was unpredictable. Stress could push it back up without warning. If it did, we would be delivering early. Any day now, she said gently. We are aiming for 34 weeks, but your body decides. I nodded. I promised to rest. I meant it, at least in theory. When she left, I opened my laptop. Not for hours at a time. I set a timer. 20 minutes working, 10 minutes breathing, water, walking slowly across the room with a nurse watching. I could not afford to spiral. I needed clarity, not adrenaline. I called Noah Patel. Noah and I built our forensic accounting firm together in Pittsburgh. He knows my thinking patterns the way some people know family recipes. When I told him about the New Jersey account, the drained funds, and the pending transaction tied to Iron Bridge Logistics, he did not react emotionally. He reacted strategically. "We start at January 2022, he said. "We map every personal and corporate transaction through September 2024. Patterns first, accusations later." Within 48 hours, he sent a secure summary. Dane had used his Iron Bridge Logistics corporate card for personal expenses, totaling $82,400, nearly 3 years of steady leakage. Spa services, high-end gym equipment, airline tickets between Pittsburgh and Cleveland, a week in Napa Valley in June 2023, a short-term apartment rental in Cleveland in March 2024. Cleveland. Lila Hart lived in Cleveland. The numbers were not ambiguous. They were deliberate, repeated, organized. Noah told me the totals were high enough that any competent CFO would care. He recommended a quiet approach. He reached out through professional channels. Gavin Cole, CFO of Iron Bridge Logistics, responded within an hour. He asked for a confidential meeting before the end of October. He did not ask about my pregnancy. He did not mention Dane. The word confidential was enough. While Noah handled the corporate angle, I ran my own credit report. 6 credit cards, all opened starting in 2022. Different banks, different marketing hooks, travel rewards, cash back, promotional interest rates. The balances across them totaled $63,700. He had been paying minimums using transfers from our joint account. Some payments hit the same day money moved into the New Jersey account. It was not random, it was maintenance. Keep the credit alive while redirecting real cash elsewhere. He was not reacting, he was executing. Then the reputational attack began. A friend texted me asking if I was okay mentally. She had heard I was struggling. Another friend sent a cautious message asking if everything at home was safe. That evening, Noah forwarded a screenshot from someone inside Iron Bridge, an internal email from Dane to HR and senior managers. He expressed concern about my stability. He wrote that pregnancy hormones had made me volatile. He wrote that he feared for the baby's safety. He wrote that he needed to protect his assets from an unpredictable spouse. Unpredictable spouse. My hands started shaking, not from medication, not from fear of losing money, from fear of losing credibility. He was not just leaving, he was constructing a narrative. If he convinced people I was unstable, then draining accounts became protection, canceling my insurance became necessity, filing for divorce while I was hospitalized became self-defense. A nurse came in to check my vitals. I slowed my breathing until the cuff stopped tightening. She asked if I needed anything. I told her no. As soon as she left, I called Sienna Alvarez. Sienna is both my friend and my attorney. She listens like a litigator even when she is being a friend. "He filed for temporary joint custody consideration," she said. "He cited mental health concerns. It's a common move. It plants doubt." I told her about the internal email, about the corporate spending, about the canceled insurance. "Good," she said quietly. "That gives us leverage." She explained we needed formal discovery immediately. Communications, financial records, device logs, anything that showed intent, evidence secured before anyone could delete it. I told her Dr. Vega said I might deliver early. Sienna paused. Then she said she would handle the legal weight. My job was to stay medically stable. 2 days later, my blood pressure spiked again. The room shifted into quiet urgency. Nurses adjusted monitors. Dr. Vega explained that if my numbers did not settle, they would have to deliver sooner than planned. That night, Sienna texted me, Discovery responses are in. I opened the file carefully, the way you open something fragile. There were emails between Dane and Lila starting early in 2024. Not flirtation, not a mistake, a plan. He wrote about me like I was a problem to solve. He described the baby as a complication to timing. He promised Lila he would finalize the divorce before the birth. He wrote that he couldn't risk me accessing certain accounts. He said I wouldn't have the strength to fight once the baby arrived. Then I saw the attachment, an PDF labeled Intake Evaluation with my name at the top, Ilara Quinn Mercer. The document claimed I had been evaluated for severe anxiety and delusional thinking. The letterhead was generic. There was no legitimate provider identifier. The formatting was inconsistent, as if copied from multiple sources. I called Sienna immediately. She confirmed what I already knew. It appeared fabricated. Real medical records carry traceable identifiers and formatting standards. This one did not. Even a bad forgery can cause damage in a custody hearing, she warned, especially if it's introduced before it's challenged. I sat back against the hospital pillows and pressed my hand against my stomach. Isla shifted beneath my palm. This was no longer about infidelity. This was an attempt to erase me legally, to build a record that positioned me as unstable, to use that instability to gain custody leverage, to justify financial transfers as protective actions. And the corporate charges, the New Jersey account, the canceled insurance, they were all pieces of the same architecture. My phone buzzed with another bank alert, a pending transfer update. I stared at the notification but did not open it yet. For the first time since the email arrived, I felt something steadier than anger. I felt recognition. I had seen this before, not in my own life, but in files stacked on my desk over the years. Financial isolation, reputation sabotage, preemptive custody strategy, asset redirection before litigation. He had built a case against me. Now I was building one against him. I closed the discovery file and saved it into a new folder labeled October 2024. This was not just a marriage collapsing. This was a coordinated effort to erase me legally, and I was done letting him control the narrative. Chapter 3: Smear Campaign and Custody. 2 days later, my body made the decision for me. It was October 19th when the headache would not ease and the numbers climbed again. The room filled with controlled urgency. Dr. Marisol Vega stood beside my bed and explained that we were no longer negotiating with my blood pressure. We were acting. Within hours, I was in a surgical suite, bright lights overhead, the air cold and metallic. I remember gripping the edge of the table and thinking that I had prepared financial models for multi-million-dollar disputes, yet I had never felt so completely unprepared. Isla Mercer was born at 34 weeks. She cried. It was not loud, but it was enough. They took her to the NICU almost immediately. I saw her for less than a minute before she disappeared behind swinging doors. A nurse leaned close and said she was breathing on her own, just small, just early. When they finally wheeled me into the NICU, I felt more fragile than she did. She lay inside an incubator, wires and monitors surrounding a body that looked too light for this world. I pressed my fingers against the glass. She moved. That was the first time since the email that I allowed myself to cry. The next week passed in a blur of pumping schedules, hospital bracelets, and short conversations whispered beside plastic walls. Dane did not come. Margot Mercer did. She arrived one afternoon with her coat folded neatly over her arm, her hair still pinned the way it always is, even in crisis. She stood at the edge of the NICU, looking at Isla with something like recognition. She asked if she could sit. I nodded. For a long time, we just watched the monitors. Finally, she said, "I know what my son is doing." There was no defense in her voice, no denial. She told me that in 1993, her husband had left when Dane was barely 2 years old. He had called it feeling trapped. He had framed it as self-preservation. She had spent years rebuilding alone. Margot reached into her purse and pulled out a small envelope. Inside were printed emails Dane had sent her months earlier. In them, he complained about responsibility. He wrote that he did not want to be stuck the way his father had been. He wrote that a child would limit his options. I read the lines twice. "He told you this," I said. She nodded. I thought it was fear talking. I did not think he would act on it like this. She hesitated before adding that she still had journals from the early 90s, entries about abandonment and financial scrambling. She said if the court needed context, she would provide it. It was the first time someone from his side stepped across the line. 3 days after Isla was born, I received a call from the trustee handling my grandmother's estate. My grandmother died in 2015. At the time, she created a trust structured to activate when her first granddaughter legally gave birth. It was her way of ensuring financial stability across generations. We had joked about it at family dinners. It always felt theoretical. The trustee confirmed that once Isla's birth certificate was registered, the trust would activate. $660,000 held separately, never commingled, legally outside marital property under Pennsylvania law. I sat in the hospital chair, still sore, still exhausted, and felt something settle inside me. Dane had tried to empty the board. He had not known there was another game piece waiting. A week later, Sienna called with an update. Lila had been served with a subpoena. According to Sienna, Lila contacted her almost immediately through separate counsel. The reason was simple and self-preserving. Dane had routed part of the New Jersey transfers through an account that briefly connected to Lila's personal bank. It was not a large amount, but it was traceable. Lila was scared. We scheduled a call with both attorneys present. Her voice sounded younger than I expected. "I did not know he was still living with you," she said. "He told me you separated in May. He said the divorce was almost final." She sent over direct messages, screenshots, and emails. In them, Dane wrote that I was unstable, that I needed treatment, that he was protecting the baby. Then she sent the same PDF intake evaluation that Sienna and I had already reviewed. Dane had sent it to her as proof that I was unfit. "Did you ever see him generate this?" Sienna asked her. "No," Lila said. "He just sent it. I assumed it was real." Lila also admitted that Dane told her the baby might not be his. He planted doubt in every direction. As the call ended, Lila said something quietly. "He told me once the baby was born, you would be too overwhelmed to fight." I looked at Isla sleeping in her incubator and felt something colder than anger. December arrived faster than I expected. Isla was home by then, small but strong. The custody mediation was scheduled for early December at the Allegheny County Family Court building. I wore a dark dress that still didn't quite fit my postpartum body. Sienna walked beside me, files tucked under her arm. Dane looked thinner, controlled. He did not look at Isla when we passed. During mediation, his attorney presented the familiar argument, concern about my mental health, instability, stress from work. Then, Dane offered what he framed as generosity. He would consider signing away parental rights if we reached a financial agreement that limited his long-term obligations. For a moment, the room went very quiet. Sienna responded evenly. Under Pennsylvania law, termination of parental rights does not automatically extinguish child support obligations unless there is an adoption or equivalent legal substitution. You cannot simply walk away from financial responsibility. Dane's jaw tightened. The mediator, Lena Park, asked if supervised visitation was acceptable while evaluations continued. Sienna agreed under strict parameters. No overnights, no unsupervised access. It was not victory, it was containment. A week later, Cheryl Whitman from the Insurance Special Investigations Unit called me directly. "We completed our review," she said. "The electronic signature on the marital status change does not match your established signature history. The submission originated from an IP address associated with your residence." She explained that the matter was being referred to federal authorities due to potential interstate elements and electronic fraud indicators. When I hung up, I felt the layers tightening. Family court, corporate audit, insurance investigation, now federal review. This was no longer a private collapse. It was a documented pattern. That night, I sat at the kitchen table after Isla finally fell asleep. The house felt different, not emptier, but clearer. Margot had left earlier with a quiet hug. My father had taken copies of certified mail receipts to catalog. Sienna had emailed the updated custody order. For the first time since the ICU, I was not reacting. I was watching the structure of his plan unravel piece by piece, and I knew the next phase would not be about emotion at all. Chapter 4. The Federal Collapse. The first email of the new year came from Gavin Cole. It was January 28, 2025. The subject line was brief and clinical: internal audit findings. I was at the kitchen table with Isla asleep in a bassinet beside me when I opened it. The house was quiet except for the soft mechanical hum of the baby monitor. Gavin wrote that the audit at Iron Bridge Logistics had concluded. The findings confirmed unauthorized personal expenditures on a corporate card totaling $82,400. The transactions were not classified as administrative error. They were categorized as misappropriation. He ended the message with a single line: employment terminated effective February 1st, 2025. I read it twice, not because I doubted it, but because I wanted to feel the shift. 3 days later, Gavin called. "We have filed a criminal complaint at the state level for embezzlement," he said. His voice was steady, but there was something underneath it. Disappointment, maybe. He had trusted Dane with access. "I understand you are dealing with separate proceedings," he added, "but the company has an obligation to act." I thank him, professional to professional. That same week, Agent Rafael Ortiz contacted Sienna. He introduced himself as part of the Financial Crimes Division of the FBI field office in Pittsburgh. The ACH transfers from Pennsylvania to New Jersey, combined with electronic signature fraud and potential misuse of certified mail, had triggered federal interest. Sienna put him on speaker during our call. "Miss Mercer," he said, "we are reviewing evidence that suggests interstate wire fraud and possible mail fraud. We will need access to digital records and any preserved correspondence." "I have everything backed up," I said. I meant it. Every email, every bank log, every timestamp. My father had done his part as well. Thomas Quinn had requested certified mail tracking records through USPS channels. He provided documentation showing that Dane had mailed a packet to Lila's attorney in October, containing the same fabricated intake evaluation and additional claims about my mental health. Those certified mail records created a paper trail that crossed state lines. "It strengthens the mail fraud component," Agent Ortiz said during a follow-up call. "Intent and transmission are critical." Intent. That word echoed in my head. Harrison Blake entered the picture unexpectedly. He had been one of Dane's golf partners. He contacted Sienna through a mutual acquaintance and asked for confidentiality. He said he had something we needed to hear. We met him in Sienna's office in late January. He handed over a USB drive. "I did not think much of it at the time," he said, "but now it sounds different." The file was an audio recording from September 2023, a casual conversation captured during a post-round gathering. Dane's voice was clear. He was laughing. He said he planned to move money before she gives birth. He said once the baby arrived, she would be too overwhelmed to dig through accounts. He said timing was everything. I felt something in my chest tighten, not with anger, but with validation. He had said it out loud. In February 2025, the indictment was filed. Sienna called me as soon as it became public record. "It's official," she said. Federal charges for wire fraud and mail fraud. State-level embezzlement proceeding continues separately. Family court and federal court moved on parallel tracks, each with its own calendar, its own rhythm. One focused on my daughter's safety, the other focused on criminal liability. In March, Dane's attorney requested a deposition. We sat across from each other in a conference room that smelled faintly of coffee and paper. Dane did not look at me when he entered. He looked at the wall behind me. His attorney began with questions about our finances. "Is it true that you manage the household accounts?" "I monitored them," I said. "Management was shared." "Did you restrict Mr. Mercer's access to funds?" "No." He tried to frame me as controlling, as obsessive, as someone who might fabricate accusations. Then Sienna began presenting documents. She placed the bank statements on the table, the ACH logs, the corporate ledger entries, the email metadata, the IP address records. "These transfers occurred from the marital residence," she said calmly. "The digital signature on the insurance form originated from the same location. The corporate card charges aligned with travel and lodging in Cleveland. The audio file dated September 2023 established premeditated intent." Objects flew from his attorney's side, to tone, to phrasing, to interpretation, but the documents did not change. At one point, Dane finally looked at me. "You always needed control," he said, quietly, almost conversational. I met his eyes. "No," I replied. "I needed transparency." The deposition lasted 4 hours. In May 2025, his federal defense attorney approached the United States Attorney's Office for a plea agreement. The risk of trial was high. The audio recording alone was damaging. The digital trails were clear. The mail records were documented. Sienna called me with the terms: 7 years in federal prison, 3 years of supervised release, restitution totaling $310,000. He would plead guilty to select counts. Others would be dismissed as part of the agreement. We sat in the federal courtroom in Pittsburgh when the plea was entered. The judge asked Dane if he understood the charges, if he understood the rights he was waiving, if he admitted to the conduct described. His voice was steady. "Yes, Your Honor." The judge asked if the plea was voluntary. "Yes." I watched his hands. They were clasped tightly in front of him. When the judge accepted the plea, something shifted in the room. It was not dramatic. There was no outburst, just a subtle recalibration. Family court proceedings continued separately. The supervised visitation order remained in place. However, given the federal charges and plea, the court temporarily suspended visitation pending further evaluation. Sienna explained it simply: 2 systems, different standards, same facts. On the day of the plea acceptance, a deputy marshal approached Dane. He was not cuffed immediately, but he was escorted out through a side door after the hearing concluded. For a moment, our eyes met again. There was no apology in his expression, no visible regret, only calculation even then. Then he was gone. I remained seated in the courtroom for a few minutes after everyone else began to leave. The weight of it did not feel like a triumph. It felt like gravity. Outside the courthouse, Pittsburgh looked the same. Cars moved, people crossed streets, life continued at its ordinary pace. Inside, the architecture of his plan had collapsed. Corporate audit, federal indictment, audio evidence, certified mail records, digital signatures. None of it was emotional anymore. It was structural. That evening, I went home and picked up Isla from her crib. She curled into me without knowing what had shifted in the legal landscape around her. I held her close and understood that the next stage would not be about proving what he did. It would be about defining what came after. Chapter 5: Judgment and Aftermath. Life did not explode after the plea. It narrowed into paperwork and court dates and quiet mornings with my daughter. The drama drained away and left structure behind. In July 2025, we returned to the federal courthouse in Pittsburgh for sentencing. Isla was 8 months old by then, sturdy and curious, her grip strong enough to catch my necklace if I leaned too close. Sienna sat beside me with a closed file on her lap. She did not need to open it. Every number in that file was already carved into memory. Dane stood at the defense table in a dark suit that looked chosen for this moment. He had trimmed his beard. He looked composed. He did not look at me. The prosecutor summarized the case. Interstate transfers from Pennsylvania to New Jersey, electronic signature fraud tied to my health insurance, misuse of corporate funds confirmed by internal audit, certified mail used to circulate fabricated claims about my mental health, an audio recording from September 2023 capturing intent before Isla was even born. When the judge asked if I wished to speak, I stood. I did not dramatize, I described. I described learning my insurance had been altered while I was hospitalized for preeclampsia. I described sitting beside my daughter's incubator while reading emails that framed me as unstable. I described walking into custody mediation while still recovering from surgery and being told I was too emotional to parent. I said accountability mattered. I said protection mattered. I said my daughter deserved stability that was not built on manipulation. The judge asked Dane if he wished to speak. He said he made mistakes. He said he felt overwhelmed. He said he wanted to move forward. It was a careful answer, measured, detached. The judge responded in the same tone. 7 years in federal prison, 3 years of supervised release, restitution totaling $310,000. The words did not hit like thunder. They settled like weight. A deputy marshal approached Dane after the hearing. There was a brief pause before he turned to follow. For a second, I wondered if he would look back. He did not. Outside the courthouse, traffic moved as if nothing significant had happened. People checked their phones. A bus idled at the curb. The world remained indifferent. The civil case continued separately. Different courtroom, different standard, same history. Our prenuptial agreement, signed in 2018, contained an infidelity clause, $250,000 payable if one spouse engaged in an extramarital relationship and concealed marital assets in connection with it. Dane's attorney challenged enforcement. He argued interpretation. He argued that the clause was punitive rather than protective. Sienna responded with documentation, the emails with Lila, the Cleveland rental, the Napa trip, the corporate card statements, the timing of the transfers, the fabricated intake evaluation sent through certified mail. The court enforced the clause. The house issue was addressed next. Dane attempted to frame it as marital property subject to division. He pushed for sale. But the down payment came directly from my grandmother's trust, structured in 2015, documented, never commingled with marital income. The trustee provided confirmation and financial tracing. The court recognized it as separate property. The house remained mine. Custody required more patience. Family court maintained supervised visitation in principle, but following the federal plea, additional review was ordered. For several months, visitation was suspended pending evaluation and administrative coordination. Then, Dane's attorney proposed an agreement. No visitation requests for 24 months. In exchange, a structured restitution payment schedule and limited administrative accommodations related to incarceration. Sienna and I reviewed the proposal carefully. Pennsylvania child support guidelines do not bend for convenience. Termination of parental rights does not automatically eliminate financial responsibility unless there is adoption or a legal substitute parent. That was not happening. The final agreement preserved child support obligations. It created clear payment timelines. It established boundaries without erasing accountability. The court reviewed and approved it. When I signed, I felt steady, not triumphant, not bitter, just resolved. In August 2025, I opened a new division within our firm, Quinn Mercer Forensics, Marital Asset Unit. not because I needed the story attached to my name, but because I understood the pattern too clearly now. Financial isolation, reputation sabotage, preemptive custody narratives, asset transfers before litigation. Noah helped me structure the intake protocols. Janet Brooks organized document preservation checklists. We built a system around the first principle my father taught me: preserve everything. The work came faster than I expected. Women who found out about hidden accounts, women whose insurance had been altered without consent, women told they were unstable the moment they questioned a bank statement. In early 2026, Agent Rafael Ortiz contacted me again. This time, he was not asking for documents, he was offering a consulting contract. The Bureau had seen a rise in marital fraud cases tied to interstate transfers and digital manipulation. They needed someone who understood both forensic accounting and the psychology of concealment. I accepted. There were still quiet moments when I walked through the house and felt the absence Dane left behind. Not longing, just space where ordinary routines once lived. But there was also something stronger in that space. My name remained intact, my profession remained intact, my daughter remained protected. One evening in late spring 2026, after Isla had fallen asleep, I checked my inbox and saw a message marked urgent. The sender was a woman named Kira, 7 months pregnant. She wrote that her husband had just emptied their joint account when she found out her debit card declined at a pharmacy. She saw a transfer to an unfamiliar bank. She ended with a question: I do not know what to do first. I stared at the screen and felt the echo of the ICU, the monitors, the $19 left in our account. Then I typed, call the bank immediately and request ACH trace details, lock down online access and change passwords, preserve every email and alert, document every transaction, consult an attorney before confronting him. Do not allow him to define the narrative. I kept the tone calm, practical, direct. After I hit send, I walked into Isla's room and stood beside her crib. She was asleep on her back, one hand resting lightly on her stomach. Dane tried to erase me from our finances, from my reputation, from motherhood itself. Instead, he removed himself from the very things he tried to control. The house was quiet, the accounts were stable, the future felt earned. If you ever found yourself staring at a bank balance that made no sense, what would be the first step you would take to protect yourself and your child, and who would you trust to stand beside you when the story starts to shift?